Let's head to Tennessee. This is the arraignment hearing for Austin Drummond. Investigators say that he shot and killed the parents, grandmother, and uncle of an infant who was found abandoned at a home miles away. Let's go into court.
Afternoon, Mr. Drummond. If you'll just go to the podium there, sir.
Your Honor, this is an arraignment today. Counts 1, 2, 3, and 4 are for first-degree premeditated murder. Each is a Class A felony. Count 5 is for especially aggravated kidnapping, a Class A felony. Count 6 is for possession of a weapon by a convicted felon, in this case a Class B felony. And count 7, 8, 9, and 10 are for 4 counts of employing a firearm during the commission of a dangerous felony. Each of those is a Class C felony.
Good afternoon to you.
Good afternoon, Your Honor.
Court has previously appointed counsel for Mr. Drummond in this case. Do you want the indictment read?
We waive full reading, Judge. Error plea of not guilty as to all counts and are requesting the court to hear this matter.
Just want to make sure, as you know, there are a couple of extra boxes we need to be sure we check there. Are counsel qualified? You qualified for lead role in death penalty case?
I am, Judge.
I feel reasonably certain
Yes, sir.
that you're qualified for co-counsel role in death penalty case. I put down an appointment order last week. Does that need any clarification
No, sir.
at all? Okay. I don't know if I put in there for future references, if Mr. Drummond wants to waive personal appearance, I need a written waiver that is specific to the date of the appearance. I'm happy for him to be here each time, but also understand sometimes he may not want to do that.
Yes, sir.
Thinking about an appearance date on Tuesday, February 24th.
Right now, Judge, I have a jury trial in Hayward County set that day.
Okay.
I'm not sure. Right now, it's set to go.
Okay. You want to go an extra month out? Or a month closer?
Here you go, a month further out.
March 24, 9 o'clock?
That works, Judge.
Yes. Or for you,
He's at 9, right, Judge?
March 24, 9 o'clock. At that date, what I'd like to do on that appearance is go ahead and set a motion date. I anticipate you all will be filing motions by that time. We'll set a motion date out there. Expert services requests, if you all, I know that you're going to get on that quickly. Email me the motion affidavit in an order, and I'll, if I need to talk to you, I'll talk to you. Otherwise, I'll sign it and get you going there. As well. My preference would be to discuss venue sooner rather than later, because you will need if that's going to be an issue, then we need to go ahead and address it on the front end.
We will be filing motion.
Okay. Also, if you anticipate, and it's as early, if you anticipate a jury questionnaire, then I'd rather look at that sooner rather than later. I know that the state has a motion for a protective order in the discovery there, and I've talked with both of you very briefly, just, acknowledging that we need to deal with it. What's the defendant's position on the protective order?
We'll discuss it with our client, Judge. I understand that we need to be here next Monday at 1 o'clock. If we cannot come to an agreement.
I have a sample or representative version of the order, I had asked my assistant to draft both directions,
Yes.
not anticipating which way we're going with it. But I have one that would serve as a protective order in there if you want to see it. If y'all are interested in it, I'll get it emailed to you.
Yes, Your Honor.
Okay. Mr. Hayes, anything else we need to take up this afternoon?
No, Your Honor.
Dr. Tupman? All right, very good. Let's see. I think Mr. Drummond has an appearance next, is it Monday or Tuesday?
Yes, next Monday at 1 o'clock.
Next Monday at 1.
Watching this hearing out of Western Tennessee, where we saw that Drummond pled not guilty to quadruple murder. Still with us, trial attorney Alexis Rosenberg. Alexis, we heard the judge there talking about this being a death penalty case and that counsel would be able to get co-counsel. Obviously, when you try a death penalty case, things are a lot more developed and you have to put forth a lot more evidence. Here, you know, I've been reading a lot about this case. Such a sad one out there. Members of the same family. People have said there's not really a motive, but the prosecutors have said just in past reports that there is a clear motive and that they will show what it is during the trial. But as we both know, you do not have to establish motive.
Exactly. You don't have to establish motive, but juries love to hear a motive. They want to know why. Why did this person do this horrific crime, even though, you know, there's really no answer for that. You know, we have these people that unfortunately have passed, and he's now on trial. No surprise he pled not guilty at this stage, though.
Yeah, and read more about him. He has a prior record here. A lot of this information most likely will not come up in trial, but a convicted felon with known gang ties, and he was out on bond for an attempted murder charge. So a lot of background here in that situation, but clearly his defense counsel will make some arguments, put forth some motions in limine in hopes of that information not getting in.
Exactly, and it looks like there might be a question of them possibly moving the trial as well. I don't know what the basis for that necessarily is, but it seems like the judge may be anticipating that based on what he just said. They obviously are going to try and do motions in limine to exclude, like you said, probably the passage, not only pending charges, but as well as, if they can, the gang, having to do with the gang and things surrounding that.
Alexis, thank you so much.